today I'll discuss about Healius and the ongoing tension caused by Australia's deficient capital allowance regimes. But before we go any further, I think it's necessary to lay out one important disclaimer. I say deficient, but it's only deficient because I use the income tax framework based on accrued income. So if this normative framework is not what we want, this may no longer be deficient. It depends. In saying deficient, our law has inconsistent treatment of so-called wasting assets, especially between tangible and intangible assets. It may be influenced by the fact that the economic literature has developed surrounding capital as a factor of production, where capital in their discipline has traditionally referred to capital assets. While the accounting discipline, which uses accrued income as their basis for setting standards, has come a long way to recognize the financial position with regard to intangible assets that last for a limited time. If tax uses the same principle, it's more logical to follow the same, but with tax policy, if you design the framework on a different basis, then we'll probably need to look at the issue in a completely different light. With this disclaimer, I'll highlight the inconsistency in our tax law between tangible wasting assets and intangible wasting assets in this presentation. Okay, my slides don't have a lot of words, so my idea is that everybody listens. We know Section 8-1 in the Australian income tax law. It's the most central provision that allows deductions for income-related expenses unless they fall into one of the exception categories. One exception is capital expense. In other words, capital expenses are not deductible under Section 8-1, and case law governs what is or is not a capital expense. In case law, we've learned that there are three primary tests. Number one, the recurrence test. Number two, enduring advantage test. And the third one being structure versus process test. I was going to actually say what Dixon said in some newspapers, but I think you're all familiar with the phrase, so I will just move on. The Sun newspapers was a landmark case introducing the third structure versus process test in Australian jurisprudence, whereas the first two tests were inputs from the United Kingdom. So this test is frequently invoked as the cause of ambiguous judicial characterisation. It makes a distinction between expenditure attributable to the structure of a business, which determines capital expenditure, and expenditure incurred in running day-to-day activities of a business, which determines current expenditure. But the major defect of this test is the subjectivity inherent in the process of inference. Now, if the structure of a business is defined as broadly as business goodwill, for example, almost all expenses can be considered capital expenditure. So, for example, the money paid to cleaners can be categorized as capital expenditure because keeping the business premises nice and clean attracts customers, thus enhancing business goodwill. Judge Brennan noted that goodwill is frequently earned and maintained by the daily activities of those engaged in the business. But he considered that the nexus to goodwill doesn't preclude expenditure from being current expenditure. So while the test tends to move expenditure from being current to capital expenditure, if I say that the judicial problem concerns moving from capital expenditure to current expenditure, none of this test is likely to be relevant. What's important in our context, therefore, is not one of these tests. Then what is it? So we need to add BP Australia Limited as another authority here. This decision was decided by the Privy Council residing in the UK, which was the last court of appeal in Australia at the time. In dealing with exclusive sales ties, the Privy Council decided to allow immediate deductions in favour of the taxpayer. The decision thus was not grounded on any particular principle or law, rather it was upon the acknowledgement that the taxpayer would find no deduction rule other than the immediate deduction rule in the Australian tax law, which the Privy Council found unjust. Yet on the very same day, the decision was handed down by the same members of the Privy Council sitting in their capacity as the House of Lords, conversely characterised the very similar kind of expenditure made for the agreement in a UK case to constitute capital expenditure. So completely different outcome there. Although there were some differences in the facts and effects, but then in economic terms, they're not really that important. Now, the case was Region Oil Co Limited and Strick in 1966. This case, of course, had no binding effect on Australian court, whereas the decision influenced by the deficient statutory rules in Australia became a legal precedent. Since BP Australia was decided in the 60s, numerous intangible cases have been tried before the Australian court. Although many assets were characterised as capital in nature, the costs for acquiring exclusive lending rights to operate public infrastructure, and collecting tolls, and authorised dealership agreements, just to name a few, were immediately deductible. The courts have conferred different weight to the three characterisation tests that I've mentioned, reaching diverse rulings, and the slide that where I said the structure versus process test was simply too ambiguous to set any consistency there. Of course, litigants know that they can't argue that an expense should be immediately deductible because the Australian law is deficient, as the Privy Council justified. Nevertheless, many cases, including Healius, which I will talk about soon, invoke the precedent of BP Australia to take the side of taxpayers. So now let's fast forward to more recent cases. Okay, so Australia has long waited another case to be tried before the High Court. The opportunity finally arose in 2019 in Shopkin. In this case, the High Court stamped capital expenditure on the costs paid to acquire multi-year gaming licenses. The licenses were regarded as assets of enduring value, and they're used as the means of continuing the business, hence categorized as part of the structure of the business. The court remarked that the decision in BP was perhaps best understood as payments incurred in recurrent dealing to encourage customers, that is, retail gas stations, to buy the company's products as a business process. Shopkin's decision was not entirely satisfactory. If the cost for acquiring limited intangible assets fell under capital expenditure, this meant that these expenses would be recognised upon disposal or when the asset expired. This would fall under the capital gains measure that were primarily designed for non-wasting assets on the ground that it's problematic to make objective measurements of changes in the value of non-wasting asset during the holding period. The absence of a capital allowance to deduct the costs of the gaming licenses leads to one of the two outcomes. First, the taxpayer gets a windfall if immediate deductions are allowed, or second, the taxpayer must pay a penalty if immediate deductions are denied. The decision in Shopkin was soon followed by Healius. The Healius case continued through 2020 on its path to elucidate judicial views in connection with a long-held precedent in BP. As with Shopkin, the taxpayer faced one of two options, either a windfall or a penalty, in the absence of the relevant capital allowance rule. The taxpayer was one of the leading healthcare companies in Australia. It made payments to medical practitioners providing services exclusively to Healius medical centres. The last Muselli case I just added because the appeal process was finalised after I submitted the abstract. It was ongoing. The full federal court decided that the payments, we're talking about prepayments here, made in conjunction with business acquisitions by way of prepayment of rent was not immediately deductible. Following the decision in both Shopkin and Healius and Muselli, the taxpayer applied for special leave to the High Court Australia in both cases. However, the High Court dismissed the application, bringing the matter to a close. So they ended at the federal court level. So we do actually have a generic so-called uniform capital allowance regime to provide depreciation for assets that have a limited life and a reasonable expected to decline in value. But assets here generally means tangible assets. Intangible assets are counted only if explicitly specified, like those dot points on the slide, and I've got more in the next slide. Okay. Now, these 8 categories of depreciable intangible assets are very narrow in scope. You may wonder why those. So I'd like to give a little bit of background of each before we finalize the discussion. We'll end up the presentation with some discussion on the cases. Now, they've been generally introduced to provide special preference to specific industries, not because of any legal principle based on their intangible nature. For example, rights and information related to mining, quarrying and prospecting have been deductible for many, many years as part of a special industry regime that recognizes various costs involved in resource extraction and processing. Patents, copyright and registered design became depreciable when the government noticed that businesses were paying excessive license fees rather than acquiring intellectual property. The cost of acquiring IP were not deductible at that time. Regarding in-house software, in 1998, the Commission of Taxation withdrew its 1979 issued ruling that had permitted taxpayers to immediately deduct the costs of software acquisition. The withdrawal happened because the Commissioner came to realize that its relatively straightforward administrative practice was not in line with the judiciary's far more complex characterization of capital current, expenditure doctrines. Now, the depreciation of spectrum and data, broadcasting, transmitter licenses was introduced when they became subject to the market auctioning systems in the 90s. This change was intended to help domestic bidders compete against international counterparts that could access tax depreciation rules in their domestic jurisdiction. IOUs for international cables were introduced in the 1999 decision to provide tax relief for costs that were otherwise recognized under the capital gains system. 6 years later, IOUs for domestic cables were added as the telecommunications industry lobby for consistent treatment across all IOUs. Simultaneously, telecommunication site access rights, often granted hand in hand with our domestic IOUs, were added. However, outside the Uniform Capital Allowance regime, the depreciation of intangible assets is limited. By default, intangible assets.
5 minutes.
5 minutes? Okay, so this I will just move on to, I think we all know how the CGT treatment works, and Ralph has suggested to introduce the generic regime for rights and leases, but it was not implemented. So the implications of Healius, the dismissal of the special leave application lodged by the Healius represented a lost opportunity to revisit the judicial standing of BP Australia in the 21st century. Now the payment in Healius case was really similar to the payment in a BP Australia case in particular. And I was hoping that it will go any further to stamp on, the High Court view on it. However, that unfortunately didn't happen. Now, because of this this stoppage at the federal court level, I expect that litigation may continue in the absence of appropriate capital allowance regime of intangible wasting assets. This calls into question the government's past decision to refuse the general capital allowance regime because of the potential complexity that the judicial doctrines judicial precedents are presenting. Given the large volume of transactions occurring every day in the market that involve wasting intangible assets, it's a virtual certainty that the absence of a generic capital allowance regime will become problematic going forward. I suppose the government can provide reassurance to those sectors of the business community that at present operate under tax uncertainty because of this unsettled issue. Okay, so that's it from me.